This panel on licensing music to users will be moderated by Ben Matelson, a trial attorney in the Media, Entertainment, and Professional Services section of the Antitrust Division. Ben, the floor is yours.
Welcome to our fourth workshop panel, Licensing Music to Users. Again, my name is Ben Matelson. I'm an attorney in the Media, Entertainment, and Professional Services section of the Antitrust Division. On this panel, we will be discussing a range of issues, including how well the current ASCAP and BMI decrees are working or not working for various stakeholders, the impact of changes in the competitive landscape on the decrees, whether the decrees facilitate or hinder innovation and entry of new competitors, and whether certain provisions in the decrees should be preserved, changed, or removed. We're going to try not to duplicate topics covered by the other panels, but I expect we will touch on some common issues. To help me explore these issues, we are extremely fortunate to have a distinguished group of panelists joining us today. Their collective accomplishments would take most of our allotted time to list, so I'll be brief. Their complete bios are posted on the workshop website. First, let me introduce John Bodnovich, the Executive Director of the American Beverage Licensees, which represents the interests of thousands of alcoholic beverage retailers, including bars, taverns, nightclubs, wine, beer, and liquor stores. John manages the ABL's government affairs portfolio, including representation before Congress and federal agencies, the organization's grassroots advocacy efforts, and he acts as their primary representative with other industry stakeholder groups. And he's been with the ABL since 2003. Peter Brodsky is the Executive Vice President of Business Affairs and the General Counsel of Sony ATV Music Publishing. He's responsible for all of the company's business and legal activities in the U.S. and is also responsible for its digital initiatives, including licensing its catalog to digital music services and other platforms. He has over 20 years of experience in the music publishing industry. Next, Rick Kaplan is the General Counsel and Executive Vice President of Legal and Regulatory Affairs for the National Association of Broadcasters. He is responsible for directing NAB's advocacy efforts at the FTC and other federal agencies. And prior to joining NAB in 2012, Rick served in key leadership capacities at the FTC, including Chief of the Wireless Telecom Bureau, among other positions. Our next panelist is Stuart Rosen, who is the Senior Vice President and General Counsel of BMI, a capacity in which he has served since 2011. He oversees global operations of the legal department, directs the organization's legal affairs, and supervises all the attorneys within the company. He has also served on the board of directors of BMI, and he's been with BMI since 1996. Finally, we have Trace Williams, who is the Executive Vice President of Business Affairs for iHeartMedia, where he advises the company on various business and legal subject matters across multiple divisions, and he is primarily responsible for the company's music rights strategy, including PRO licensing. He has more than 20 years of experience in the music industry, and before joining iHeart, he was the General Counsel of music tech startup Thumbplay. Welcome to all the panelists, and thank you for being here. Let's move into some questions and answers. As many in our audience may know, the Antitrust Division solicited public comments on the decrees in 2019. We received over 800 comments raising a wide variety of issues. The first issue I'd like to discuss with you is the impact of changes in technology in music distribution and consumption in the 20 years or so since the decrees were last revised. ASCAP, in its public comment, notes, with the advent of new technologies, the increasing availability of wireless and broadband services, and the proliferation of devices capable of streaming audio and video content, the model for content distribution and consumption that held true for more than 60 years has materially changed over the last 2 decades, and with increasing rapidity in the last few years, unquote. BMI's comment also makes a similar point, and so I'd like to start off by asking Stuart Rosen of BMI, given these various changes in the landscape, are the consent decrees out of sync with how music licensing is done today? And do they need to be modified in some way to reflect these changes in how people are consuming it?
Well, thank you for having me. I'm here to answer any of your questions. Before I start, though, I like working at BMI, and my board would want you to know that I was the corporate secretary. I didn't actually serve on the BMI board. To answer your question, certainly technology has impacted the way music is licensed. You don't have to look farther than digital music services, where when our publishing affiliates make direct deals with them, which they do often, they will combine multiple rights within that license because the nature of distribution of content online requires more than a single right. But I think to answer your question more broadly, and please indulge me because I do want to kind of set the context for this discussion, I think it's the competitive landscape that has really changed more than anything else. And there's not anybody on this call, and there's not a single participant in the marketplace that isn't in a much different position today than they were when the decrees were first entered into. Forget about 1994, when the decree was last modified. So if we start with PROs, there are more PROs today than ever before, and they're not small competitors to BMI and ASCAP. CSAC is funded by a venture capital firm. GMR, certainly well-funded, serious competitor. So that's changed. If you look at direct licensing, where in essence our publishers are competing with us for those licenses, you've seen a dramatic increase in that, particularly with the rise of digital, but not exclusively to digital. If you look at foreign PROs, they are not currently competing for our business, but particularly if you look in the digital area, there's no reason why they may not find that an attractive option in the future. But it's not restricted to the changes with the PROs. If you talk about from the licensing side, from the licensee side, if there was ever a concern that BMI was negotiating with mom and pops, well, these days we're negotiating with the FANG companies. And if there's a Goliath in that equation, it's not BMI. Our publishers have grown similarly, and they're part now of huge entertainment conglomerates, and that really informs a different change, a different relationship with BMI as an affiliate, as a member. Where I think there's really been a profound change that I wish was maybe explored a little bit more on yesterday's affiliate panel is the choices that our songwriters have today. I think songwriters have more choice today regarding PROs than they ever have, and not just number of PROs. Every PRO goes about it differently. If you're talking about duration of affiliation, as we were yesterday, if you want a one-year agreement, go to our friends at ASCAP. If you want an agreement for a little bit longer, you come to BMI. And if you want a relationship that's longer than BMI can give you under our decree, you have unregulated PROs as well. It goes beyond those terms. We have different rules for membership. They're all published. They're all available online before you sign on the dotted line as an affiliate. We value distribution differently. That's a key consideration. And these days is a consideration as to whether you are or aren't regulated. If you want to be under a PRO that's governed by a decree, you can do what John Bon Jovi did for most of his career and stay within a regulated PRO. And if you think that there's greater freedom with an unregulated PRO. You can do what John Bon Jovi did and join an unregulated PRO. So I think certainly from a songwriter perspective, there's an enormous amount of choice, and I think that's proof that you don't need a decree to regulate that part of the industry. Last thing I want to say is this is a behavioral decree, and that means you ought to be looking at BMI's track record of behavior over these 80 years if you want to see if the decree is still a good fit. As Mike O'Neill said yesterday, BMI's never been found to be in violation of its decree by the DOJ in all this time. And I was a little surprised yesterday when David Kokakis may have suggested that the PROs might be interfering with direct licensing. In that space, we certainly compete for those licenses, absolutely. Do we assist in some ways on those licenses? We do admin for a lot of those deals, so we certainly do, but we do not interfere with that. But look beyond the fact that BMI has been a good corporate citizen and a good citizen under the decree. Let's look at what BMI does that we are not required to do. The types of licenses we offer go beyond the minimum. Mike Steinberg yesterday talked about a claims-based license. It's not required by the decree. Talked about through to the viewer licenses. We license well beyond the strict broadcaster category that our decree requires. If you're an affiliate, we could require that you affiliate for many, many more years than we ask of our affiliates. So we're not even pushing the limit there. And if you're talking about databases, I just want to remind the group that BMI doesn't have a requirement in its decree to provide works data, and yet we've been doing it for decades, only because we're trying to meet the needs of our customers. So to wrap up, when you look at all the different factors, when you look at the changes in every one of the market participants, and you look at BMI's behavior, the decrees don't really make a lot of sense, and that's why we're advocating the move to a modified decree eventually towards sunset. Thank you.
Okay, thanks. I appreciate the setting the stage. Let me turn to Rick and ask, what is your response to this idea that the competitive landscape changed dramatically and therefore the decrees should be modified? What is NAB's view on that?
Well, first of all, thank you, Ben. It's great to join Stu and the rest of this very esteemed panel. And I'd also like to thank Assistant Attorney General Del Rahim and the Antitrust Division for inviting NAB to discuss music licensing. These issues, as you've heard about and you'll continue to hear about, are complex and incredibly important. Ben, the fact that there are new music platforms in no way whatsoever changes the essence of performing rights organizations, meaning they simply do not compete for licensees. While they may compete on the songwriter side, they don't compete when it comes to licensees like broadcasters, and you'll also hear from the beverage licensees as well. Nothing has changed in the last 60 or 80 years that has altered the fact that PROs are, in antitrust terms, cartels. Broadcasters, for one, rely on PRO licenses in the same exact way they did in 1941. And this isn't just my opinion. Indeed, every prior administration over the past 80 years has agreed, whether implicitly or explicitly, that the decrees serve the public interest and they remain necessary. Speaking of which, I find it somewhat amusing over the last day or so that many of the participants during these roundtables have really leaned in when mentioning that the ASCAP decree is almost 80 years old. It sounds ancient. And while it's true that the department birthed that decree in 1941, the very same department just renewed its strong commitment to the decrees in 2016. So, and actually the courts, on top of that, reviewed the ASCAP decree as recently as 2000. So while I love a good rhetorical flourish as much as the next Washington lobbyist, the true metric here is 4 years. It was just 4 years ago when the government thoroughly reviewed the decree. So the question here, when the department looked at these things top to bottom and determined they were essential to the public interest, it's really in just the last 4 years they made that determination. And there are no changes that anyone can seriously argue have occurred over the last 4 years that changed that competitive landscape. And the last thing I'll say, and we work very closely with BMI and ASCAP, and Stu's really great. But the one thing is, and Michael Neal mentioned this yesterday too, this notion of never violating a decree. That's not really the standard in any kind of law, let alone antitrust. You're supposed to adhere to your decrees. What the decree is trying to address is the incentives created by the structure. And in this case, the structure is by amassing all these rights and asking the government to be allowed to sell them in a way that could certainly charge super competitive rates, right? So as a licensee, as a broadcaster, you cannot choose between ASCAP and BMI. You don't go and say, oh, I've got ASCAP locked down, I don't need to worry about the rest of that. Because you need both to operate, whether it's TV stations or radio stations, you have to have both. And now you need GMR and CSAC. So these are all must-have catalogs. You need these repertories to be able to operate. So the fact that they haven't stepped out of line from that doesn't actually suggest anything, because there have been, they obviously want to adhere to the law, and the folks at BMI certainly want to and do. But if the law wasn't there, then that would be big trouble for licensees.
Okay, thank you, Rick. Let me bring in John, because I'd like to hear the perspective of his members, which include a number of smaller businesses like bars that license music. And can you give us a sense from your perspective, John? These technological changes that we've been talking about, and the way music is distributed and consumed. Has that made the decrees less relevant for music users like the ones you work with?
Sure. Well, Ben, thank you so much for the question. I want to thank you. I want to thank Assistant Attorney General Del Rahim, Karina LaBelle, and the team at the Department of Justice for so swiftly bringing this workshop together. I really appreciate the opportunity to be part of this panel and share a small business perspective as the true David to the many Goliaths that have been mentioned yesterday and already again today as part of this workshop. As you mentioned off the top, American Beverage Licensees represents thousands of independent bars, taverns, as well as liquor stores across the country, many of whom, particularly on the on-premise side, purchase licenses for the public performance of music in their businesses. My members and the on-premise community have long been engaged in issues surrounding music licensing. And before I directly answer your question, I just want to just indulge me to take just a quick moment to acknowledge a couple things that are really inescapable in our day and time. First is the COVID-19 crisis and what it's meant for the hospitality industry, in particular bars, taverns, and restaurants. I've listened yesterday and again to John Bon Jovi today talk about the plight of songwriters and the issues that they're having in terms of the shutdowns and whatnot. But those are direct effects as well, and we can relate on my members. Since mid-March, many bars and restaurants across the country were closed down for up to 100 days, forcing them to lay off employees and go through quite a bit of financial trauma. We're now seeing reclosures of those businesses or even limitations to their seating capacities and open hours. A lot of those businesses are essential businesses. They provided food, beverages. Our friends in the hotel industry have provided housing for first responders, and really have served as a gateway to other critical staples during this crisis. So we view it as imperative that our members be permitted to continue providing services free of distraction of unrelated matters to the current crisis. So as the Department of Justice considers making changes to the consent decrees, take in consideration potentially burdensome changes to hospitality businesses that could come from this review. The other quick point I will make before responding directly is just a note that I very much appreciate being here today, again, as the David, but I want to just point out that as a venue organization, so to speak, in the music licensing ecosystem, we're just one group of, I think, a community that's a little underrepresented during the workshop yesterday and today. Relatively, our individual businesses are small, but collectively we pay tens of millions of dollars in licensing fees each year. And just as without the PROs, songwriters would not get paid, without venues, they wouldn't have their songs played. And that's important to keep in mind. So as kind of the other half of that dichotomous relationship, I just want to emphasize, I think it's important that the hospitality industry has its voice heard, and again, appreciate the opportunity to share that today. To answer your question, the basic operational functions of the licensing of licensing collectives and the mutually beneficial and essential efficiencies that are provided both to songwriters and to licensees really have remained consistent and constant and vital through the time that they've been in existence. For bars and taverns, most of them avail themselves of a blanket license. Not that much has changed. The advent of internet and technology allow for online payments and new commercial platforms for providing music to customers. But really beyond that, you still have music and retail businesses and musicians performing live in bars and clubs as they have for decades. And obviously that's in a pre-COVID-19 reality, and hopefully one that we return to soon. So with all that said, I just want to point out a few things that we view the relevance of the decrees to this day. First and foremost, they provide protection from anti-competitive behavior, thanks to the existence of reasonable rate setting mechanism and counterbalances ongoing price collusion. I think that Rick was kind of leaning into that a little bit. They allow bar businesses to when they open their doors, to be able to play music. Bars and taverns know that regardless of what type of bar they are, or where they're located, or what type of music they play, they're going to be charged a rate akin to other similarly situated businesses. So they can rely on that knowledge. They know that with an efficient blanket license, they significantly reduce their risk of copyright infringement and the need to individually license with thousands of artists, which we know they just wouldn't be able to do. And finally, and perhaps most importantly, they know that through this process, the fees that they're paying are going to be distributed to their fellow small business people, in particular songwriters. So, we view them as relevant today as ever before, regardless of other potential changes that may be going on in the music business. It's very much a similar situation for my members today.
All right, great. Thank you for the perspective. I also wanted to ask Peter to weigh in on this from the publisher perspective. Have these changes in the competitive landscape made the decrees less relevant today than prior to the digital era?
Okay. Well, first, thank you to the department for putting on these workshops and for inviting me to participate. I just want to mention that I am, as Ben mentioned, the general counsel of Sony ATV Music Publishing. Here today in that capacity. I also sit on the board of directors of ASCAP. To get to the question, for us, the need for the decrees depends on the type of user. The decrees still serve useful purposes for bars, restaurants, terrestrial radio, and other broadcasters. For those types of businesses, the decrees were put in place to address a failure in the marketplace and allow for collective licensing. That need still exists today. But the decrees were not designed for the modern music business, where a handful of the largest and most powerful companies in the world control the audio streaming business. Simply put, one size does not fit all. Collective licensing is not needed for the audio streaming business, where you have a huge concentration of that business controlled by a small handful of companies. And the companies that control that business certainly don't need the protection of the antitrust laws to protect them from songwriters and music publishers. It's actually unbelievably ironic that literally as we sit here right now, those companies are in Washington defending themselves from claims that they're too powerful. That's why, at Sony ATV, we believe the decree should be amended to allow for the withdrawal of our digital streaming rights, which will allow us to negotiate in a free market. The fact of the matter is that we already engage with those companies for rights such as lyrics and video, which we're able to negotiate in a free market. And we don't believe there are valid antitrust reasons for not adding performance rights to that list.
All right. Anyone want to respond to any of the points that have been made, or we could move on to the next topic if we're ready. Okay.
I think I'll just quickly note, and obviously we don't, unfortunately, there's not a representative from those services on this panel, which I think would be useful. But just from that side of the house, I think it's important to understand that whether or not there are large companies involved, and obviously NAB, for example, represents large and small, it's very important to understand that none of that changes the context of the PROs and their ability to exact super competitive rates. And actually built into the process, what makes the consent decrees, why they've lasted so long and been so effective, and music has really developed and flourished during that time, is that they allow for that. So the courts, and we'll get to this in a minute, do account for what would be a market rate that would be negotiated. So they can take into account those sorts of things. So if there's a bigger company on one side, that's certainly something that they can account for.
I think at a later point in this panel, we're going to get into whether the rate courts are effective at actually doing that.
That's right, right. And we will circle back to many of these issues that we've touched on. Um, so, okay, let me go ahead and move on to the next topic, which is the area of innovation. Um, and we're interested in how the decrees affect the ability of innovative new business models to enter on the user side of the market. We talked yesterday about the PRO side and the songwriter side. But for the users, do the decrees facilitate or hinder new entry? And are there any examples you can point to that might be helpful on this? And let me start by asking Tracy to weigh in on.
Sure. Also saying thank you for having me. Thanks to Mr. Del Rahim and the division for putting this together, an important topic to have an open discussion about. iHeart is a friend of the music industry. Connecting fans with the music they love is really core to what we do. We love to promote music. It's really, if you think about what radio and now our digital services through the beauty of the consent decrees have been able to do is innovate and delight fans with music they love and bring new music, introduce new music to the public. And we take that core role seriously, and we really are focused on paying songwriters fairly and efficiently and quickly, and think that the consent decrees actually do a really good job of that today, as they are. Echoing what Rick said earlier, music licensing really isn't a free marketplace. We don't have a choice between ASCAP and BMI. It's not Coke and Pepsi. We have to take both. They're both must-have catalogs, and what hasn't changed is that those are the dominant players in the licensing of performance rights by far. Also, we don't always control the music that we play, nor do we know who the songwriters are for new music. So those problems add to the complexity that are really facilitated by the efficiency of the blanket license. So, from our point of view, the consent decrees have worked very well. In terms of innovation, over the last 10 years, iHeart has done a lot to change its business and really transform its business from a traditional radio company to a company that does digital radio, simulcasting our radio stations, bringing music to fans wherever they are and on any device that they want to listen to it on. I think there have been other panelists that have sort of marveled at the idea that you can go back and, listen to a song that was the favorite song of your childhood without having to sort of dig through your old record collection. And I think that kind of innovation is really what has been facilitated by the protections afforded by the consent decree. The consent decrees, the ability to feel comfortable that you have a license upon request, the protections of the rate court to set a fair rate, including being similarly, non-discrimination, being similarly situated, and again, have that efficient process. I think, it's amazing to follow John Bon Jovi on a panel like this, being somebody that also lives in Jersey, exit 151. But I think he mentioned earlier today just, that they serve a critical role of making sure that songwriters get paid in an efficient way and fairly. And so that to answer your question, I think that they're critical to promoting innovation.
Okay, let me ask Stuart to weigh in on this. What's your perspective on whether the decrees are helping or hindering innovation?
Thank you. Well, first, before we get there, Trace, all of us on the panel can tell our kids that John Bon Jovi opened for us, which I think is kind of awesome. But to the point of similarly situated, we do find it a restraint, a constraint on BMI. The interesting thing, which maybe not everybody realizes, is that more often than not, it's the user, it's the licensee who's coming to BMI trying to get us to take a different approach. They believe their business model is different. They believe they need a different approach. BMI would love to meet the needs of every one of our customers, but the rubric we have to go through is, are we going to violate the consent decree in doing so? They may have a different approach. It may be a scrappy startup like iHeart that wants to use, they have a lot of music, but they don't yet have a lot of revenue. We're constrained in what we can do, and we'd love to be able to meet that challenge, but can't.
just to follow up on something that so your colleague, your BMI colleague, Mike Steinberg mentioned yesterday, that the decrees have sort of slowed the introduction of new license types by BMI. And I was wondering if you'd care to elaborate on that and talk about what issues you were facing that made it difficult to innovate in the area of licenses.
Okay. So let's imagine a real scrappy little startup, and they're coming to BMI, and they have an idea for a new approach. Or let's say a bigger group comes to BMI and wants to have a different pricing structure than anybody else has done. This is an optimal chance to have a pilot program, to try it out. Maybe it'll succeed, maybe it won't. But it's the kind of small risks you can take in the hopes of being innovative. When you overlay on that an obligation that if I do it for that startup, I'm going to have to do it for everybody else, and I don't have a choice in the matter, the whole risk calculus changes. And so we are necessarily more risk averse when to try something new could carry the implications of carrying over what might not be a successful program across a class and category.
Great, thanks. So what you're touching on is where I wanted to go next, which is the similarly situated provisions, which have long been in both trees, and they say that the PROs may not discriminate in license fees or other terms among similarly situated users. So is there still a need today for these types of non-discrimination provisions? And for the licensees on our panel, like how important a role do these provisions play in the pricing for your industries? And let me start off with Rick on that.
Sure, thanks, Ben. Really important. I'm sitting here somewhat a little bit flabbergasted at what Stu's saying because licensees have had to go to court to enforce the provisions of the decrees that allow for things other than the blanket license. So there's a history here of licensees wanting to do different things, and not because the PROs feel like they can't do it, but because it's not economical in their view to continue to do it. So they don't allow that to happen. So licensees have to actually go to court and get the decrees enforced to allow that to happen. So only because of the decrees have there been able to be things like the adjustable fee blanket license. So that actually makes the point of why they're so important. And if there's a misunderstanding, I think one of the critical things here is small users, and I'm sure John will talk about this too, small users, and we represent a lot of them, thousands of radio stations who are very small, who rely on that because they can't go to rate court. It's not easy for them to go to rate court. And if every time a PRO could just be like, well, you're going to have to go to rate court to get the fee you want or think is reasonable, that's a problem. So similarly situated is an important way of allowing the small broadcaster and a lot of small licensees to have some comfort that they'll be able to get in the door. And if you want innovation, if you want new things, if you want choice, I think that's critical. It also sort of strains credulity to think that the Justice Department in enacting the decrees of the courts, that they would have the decrees be something that would not allow the PROs to drop prices, right? So if someone came in and said, look, hey, I've got this innovative model. In fact, I'm going to maybe use more of your repertory if you give me a better deal. That's allowed. That's not, I know that a lot of licensees say that they hear from the PROs, oh, well, we can't do that. They can. They could lower prices. It's not maybe in their interest to do so, but that is something that is allowed today. And in fact, the decrees do not allow, let's say a new deal is cut by BMI. It doesn't allow someone to go in and say, oh, well, you need to change my existing deal. That's not allowed. It would affect maybe future deals perhaps, but again, you couldn't open up a current deal and redo that.
I can respond.
Yeah. Let me. I wanted to go to Peter next, and then Stu, you can follow.
Thank you.
So now I get to open for you, Stu. Listen, on this point, it's actually surprising to me that we all don't agree. The similarly situated provisions from Sony ATV's perspective, and others on this panel, I think, hinder innovation, and we don't think they're necessary. As a practical matter at Sony ATV, when a new licensee comes in the door, we look at if there are any similar businesses that we may have previously licensed, and we use that as a starting point. But the point is, similar is never the same. Even if it looks the same on the outside, when you dig into it, it's never the same. There are always differences, and we're able to then tailor that license and the deal to a licensee's particular needs. So we don't think that ASCAP and BMI, should have their hands tied by a similarly situated requirement, and we don't think it's good for licensees either. I think this is to me an easy one.
And can you explain why is it bad for licensees?
Because because of the innovation, because similar is not the same, and if they've got particular needs, then a deal can be cut to tailor their specific business.
All right, thanks. Stu, can you respond to some of the points Rick was making? And then also maybe you could address, do you believe the similarly situated language needs to be updated or revised in some way, or are you advocating that it should be removed entirely?
Well, we think it should be removed entirely, but let me, to sort of explain that, let me address some of Rick's concerns. First of all, let's talk about small businesses. If you're looking at the eating and drinking establishment category, about 40% of that category is made up of what we call minimum fee licenses. There's no negotiation there. It's a rate card. It's sign on the dotted line and use the music. BMI has zero interest in engaging in 22,000 different negotiations with minimum fee licensees or 60,000 in the category. And it's not just on the brick and mortar area. If you look at digital licenses, 80%, nearly 80% of BMI's digital licenses are minimum fee licenses. That's not where the negotiation is going to happen. Where the negotiation is going to happen is with some of the people on this call. When they want a modification, they want a different approach, and we want to be able to meet their needs. As another thing for small businesses, though, it's incredibly prohibitive. It's prohibitive for everybody to go to rate court, and it's especially prohibitive for a small business to do so. Luckily, for the last 22 years, the Copyright Act has provided in 17 U.S.C. 513, I believe, it is what we call the circuit rate court. It is a localized proceeding where small businesses, and it's defined in the Act, can bring individual proceedings in their local judicial districts in front of a magistrate judge who will ultimately make a recommendation to the rate court judge. These are cheap, they are streamlined, they're easy, and you know what? Nobody pursues them. In 22 years, we've never had a case gone to trial, by my memory, and I'm not even sure you can count on a full hand the number of people who've even filed it. But the remedy, to be sure, is there. Final point. If we got rid of similarly situated today, there's an awful lot that prevents BMI from being completely arbitrary in what it chooses in prices. There is rate court itself for the big users. There is a long-established line of case law. And there's this little thing we keep not talking about, which is antitrust law. Antitrust law is not going away. And so there are certainly constraints on all of your concerns, Rick, but I don't think we require a decree, and certainly not a decree with its current constraints, to get to that destination.
Ben, can I jump in real quick?
Sure. Actually, I wanted to, before that, I was hoping to hear Dom's perspective, since you mentioned small businesses and much negotiation with your members.
Ben, you cut out a little bit on your volume.
I'm sorry. Hopefully you can hear me.
Yep.
Yeah, that's better.
So I wanted to get Dom's perspective on this. Stu mentioned the fact that there are many of your members that don't directly negotiate on price. And to what extent do they rely on these similarly situated requirements to ensure that they're getting a fair price? And what would happen from your perspective if those provisions in the Constitution went away?
Okay, I didn't catch the last part of your question, but I'll try and.
Sorry, it was just what would happen from your perspective if those similarly situated provisions went away?
Got it. Okay, so I've spent a lot of time over the past decade working with my members to try and improve relationships between on-premise, hospitality licensees and PROs. It's been a very damaged relationship over the years. And if you talk to your average bar or tavern owner, they're going to tell you that the business practices that they've experienced over the years with companies like ASCAP and BMI have been troubling, to say the least. Now, I think that a lot of that's improved, and I give credit to ASCAP and BMI for taking steps to go in the right direction in terms of their customer relations. But I think there's still a ways to go. And I mentioned that because I think that colors this conversation. It colors the perspective of their clients, of the people who are purchasing these licenses. So while I would like to think that removing these provisions for similarly situated would lead to a floodgate of goodwill and discounts and new opportunities for innovative operators, I just don't know if there's any evidence that points to that being the case. So I think it's a lot for these small businesses to see these entities that wield this fantastic amount of power and just say, no, take us at our word. We're not going to try and adjust the 40,000 accounts that Stuart just mentioned. I don't know if that's going to be in writing anywhere, but I think that's the kind of reaction that you're going to hear, and the one that I would suggest is more commonplace out there. So, beyond just that trust factor as well, I think you look into viewpoint discrimination issues, picking winners and losers, and how that can affect a business, in terms of what they're paying for their fees and their ability to have a license whatsoever. So if you get into that, it gets devastating. Yes, there are remedies through the courts. I agree. But a lot of the challenges there have to do with the resources of these small businesses. The idea of getting into this some sort of asymmetrical litigation with a bar and tavern, or even a small group of bars and taverns versus ASCAP, BMI, whomever, is really kind of scary for a lot of small business owners. So I think that's the perspective that they're looking at, is that there may be opportunity, but that is far outweighed by the risk of what potentially could be done to them, if the similarly situated provisions are removed. I just close on one last thought. We're talking about innovators and innovation, and I think, and I know we're going to lead to this, but we should also start by talking about data and knowing the universe we're dealing with, and allowing that to be, help innovation. So I know we're going to get to transparency and database conversation, but to me, that's part and parcel with all of this as well.
Okay, and Rick.
Just quickly, I am cynical, and I grew up in New York, so exit 50 Long Island Expressway, Trace. So, but you don't see anywhere in the record licensees aren't asking for this, right? So you would see, if what Stu is saying is true, you would see lots of examples on the record of licensees saying, "Hey, look, this provision is too restrictive. We really want to be able." That's not the case. So I think that's just an important thing to think about. At the point where licensees are saying we really would like that removed because it actually could really help us, then you'd see maybe it is pro-competitive.
Okay, and let me go to Trace for a final perspective on this. Do you believe the PROs have sufficient flexibility to offer the kinds of special discounts or deals that Stu was talking about as the decrees are written, or do you think more needs to be done on this?
So it's an interesting hypothetical question, and we haven't been offered discounts in our negotiations with the PROs. In fact, what I've read from folks like the ASCAP's economist as part of the review of these consent decrees suggests the opposite, that if the consent decrees restrictions were removed, that prices would go up. In terms of similar situation, I'll echo some of the other comments about it really protecting the smaller users the most. I agree that it would be important to clarify that the rate court is charged with determining reasonable rates, and so there is built-in protection of the rate court that if the rate court were charged with determining reasonable rates, one benchmark I'm sure they'd look to would be other deals that were done in the market. And so there is sort of a built-in similarly situated protection. But I think, requiring sort of users to go through the steps of having to go through to the rate court is going to be prohibitive for the smallest users. And so, I am sympathetic to the sentiments of John and, Rick, I think also expressed the sentiment that, small stations really would, are exposed if the similarly situated provisions go away.
If I can, Ben, just very, very quick points.
Sure.
We're talking in terms of the similarly situated provision, and that's certainly an obstacle as we see it. But when we're talking about discounts, we're also moving over to a different prohibition in the decree, which says that I can't give you a discount in return for you promising to play a certain percentage of BMI music. So I don't want everybody to think that it's only the similarly situated obstacle. We think that discount programs like that could work for everybody. It might lower the fees of a user. It would increase the performances, which would benefit our affiliates. So in that sense, we think it's good for the marketplace. And as to the question of why, we've never brought up discounts, that's the reason. The reason we haven't brought it up is because we can't bring it up.
All right. Thank you. So I want to move on to a topic that John just touched on, which is transparency of the repertory. And several commenters have raised concern about the ASCAP and BMI databases, and I wanted to get some thoughts on that. What is missing today in terms of the content and the functionality of these databases, and should the decrees require a more robust disclosure? And let me ask Trace to weigh in on that first.
Sure. Well, this is an area that could certainly use some improvement in terms of transparency. I think there's been a lot of discussion about the databases that ASCAP and BMI put together, and certainly over the last couple decades, that's sort of come a long way from, sorry, I can't tell you, to it's available on our website. I think it still comes short, though, of what would be needed to really promote competition with direct licenses. It needs to be machine readable and in real time. And I think those are, a couple of things that sort of get lost in this is, we need to be able to, in real time, ping a database. We know who owns it, what the shares are, and feel confident in that, and feel confident that all the licensors are essentially in agreement on that information. Another problem with this transparency issue really is new releases. If you think about the songwriting process, which, as a huge music fan, I just love the idea that songwriters sort of get together in the studio and work late into the night and come up with something they think is a real big hit, and the next day it's on the radio. And I think that reality really makes it difficult to understand who, and in many cases, the songwriters themselves haven't even agreed on who owns what share. So I think these are just real world examples of what makes sort of transparency, really important, that we sort of get the information as quickly as possible and in real time, like I said, and not something that I have to go onto a website and search, or sort of search a database manually. That idea that it's really underpinning all of the things that I think we're going to spend a little bit of time talking about, direct licensing, and being able to take advantage of some of the alternative forms of licenses, which I think today the kinds of licenses that have been offered as alternative forms are effectively illusory, because you can't save money unless you license such a large portion of the catalog at such a large discount. And I think there have actually even been publishers that have talked about those disincentives to direct licensing. So these are the kind of things that would really, transparency is one of the things that would underpin a program like direct licensing. And, we're not talking about hundreds of songs, we're talking about millions of songs. So it really does need to be sort of machine readable, automated, in real time updated with accurate information. I'll give one more example of, just in the last 24 hours, I spent a little bit of time preparing for this panel searching ASCAP and BMI's database, just to get a little idea of how things are progressing, because I know they've been spending a lot of time working on the accuracy and reconciling those databases with the other databases out there. And interestingly, I looked up a couple GMR writers, and both ASCAP and BMI's databases sort of inaccurately reflect that those writers are unaffiliated. So just a couple of examples of, where there's not great information out there and it's not accessible in a great way that would facilitate direct licensing.
All right, thanks. Let me go to John for his thoughts. Do you agree with Trace? And then I'll throw it over to Stu to respond to some of these issues. So John, you go ahead.
Sure. Thanks, Ben. I agree with Trace to a large extent. I think it's, there's an agreement, right? And ASCAP and BMI recognize there's a need for more greater transparency in the database. And I know the hospitality industry and other businesses like licensing organizations have called on Congress to create a neutral, reliable, comprehensive database. As Trace mentioned, machine readable, real time, be accessed and used by licensees or third parties who probably want to get paid and build out their own businesses on that. I think one of the couple of issues we have with the current state of affairs, it's just from a very practical perspective. You're a bar owner, you order a case of Jack Daniels, you pay for it, you're going to get a case of Jack Daniels. Right now, you're going to get a license, and you kind of know what's in there. I'm not 100% sure. I think in this day and age, about the advances in technology, hopefully we're getting there. I have to say, I was a little like yesterday hearing about that reconciliation engine that was being created. It's funny, 3 years ago on Sunday, like 6, the ASCAP BMI announced a database and announced creation of a new comprehensive music database to increase ownership, transparency, information, rights licensing. That's great. And it was ready for the end of 2018. It already been worked on for a year, and that's all good. But here we are, 4 years later, and now we're waiting for a reconciliation engine in a year. I don't disparage their hard work, but I don't think it's enough. We need something that's larger, more comprehensive. And let's also remember that database or reconciliation engine is going to take consideration by repertoires. One includes music from data from CSAC and GMR or any of your heroes tomorrow. Now, fractional licensing that may not be as helpful as it could be. Again, that's kind of where we fall on. We think it's going to be a big thing. We think everyone would benefit from it. Everyone involved in the system, songwriters included. And that's why we would like to see one that's neutral, used by third parties, and lots and captures as much data as possible.
Ben, now it's hard to hear you.
You have a little bit of an echo on your audio, so we're having trouble hearing you. So, but let me go to Stu, and hopefully we can figure out that audio issue. Stu, do you want to go ahead?
Yeah, I think John was just saying that our databases were perfect and he relies on them all the time. I think it's what I heard. Let me start with something Trace said, and he was talking about how he went on our site and he couldn't find information on GMR. I think he put the finger maybe inadvertently on the problem in this discussion. GMR ought to be the definitive source on GMR information. And I guess my question to the group and to the DOJ is, why should the failure of BMI, assuming we have a failure, to provide accurate information on GMR be a consent decree violation? Why should that be the burden of our affiliates to finance? I just don't see how that becomes our obligation. As I see our obligation, it's to make sure that a user knows what they're buying when they buy a BMI license. And to that point, we've met that challenge. And we've been doing it, as I said earlier, for decades without any consent decree requirement. We started with paper books that might have been out of date before the ink was dry. We moved to CD-ROMs, and we moved to electronic databases, and machine readable is certainly something we're looking at and we'll get to eventually. But right now, what BMI and ASCAP are doing together, again, not required by a decree, is to work on our SongView database, which we're really excited about. It's an incredibly difficult undertaking to take two separate databases that have operated under two separate approaches and combine them into one reconciled view. But that's exactly what we're going to do. So, I think everybody wants good data. We're striving to provide better and better data all the time. That to me is a different question and a different discussion than to whether a consent decree requirement ought to be in place to have us be essentially custodians for industry-wide information.
Thanks. Does anyone else want to weigh in on that?
Yeah, I mean, I guess I'd just say it's a little disconcerting to hear BMI sort of say it's not our problem on transparency. I think that, like I said, it's an underpinning of direct licensing. It's an underpinning of promoting competition in this space. It's the reason that, at least in one of the consent decrees, it's required. So I think sort of strengthening that and making sure that the databases are accurate and it's something that the parties, that the licensee community can rely on. I think it was said in some of the panels that the MMA, the creation of the MLC, it should help to improve that, and I think we're optimistic that that will go some way towards improving this situation. But look, it's been a long time. We've been talking about this a long time. I think everybody knows what we need to do. It's just a matter of getting serious about doing it. And it really remains to be seen sort of what the MLC comes up with.
I think this highlights two. That's
not what I said. And if we're talking about transparency about what? We are fully transparent at BMI about our own data. And not only that, we stand behind it with our indemnification provision once you sign a BMI license. So we may be talking about what you want to have information about, but when it comes to the boundaries of BMI, we're fully transparent.
Well, and Stu, as long as that indemnification license covers folks who, because of fractional licensing now, there's a piece that is GMR or CSAC, and they, did what they could to acquire a license but couldn't do it. I think that's really important. I think this also highlights the conversation that you and Trace were having. I think it's interesting why we think that if there was any changes to the decrees, it should be brought in to include GMR and CSAC so that everyone's under the same set of rules. I think that would be important and maybe would lead to this collaboration that's just essential for, as Trace said, direct licensing, or even just to make sure that you don't run afoul of the copyright laws. And I see you agree, Stu.
Can I just chime in at the end of this conversation?
Yeah, please do.
Like ASCAP and BMI, Sony ATV also makes all of its information available. We've been doing that on our website for 7, 8 years now, I think at the least. It's got all the relevant codes. It's got the song splits and things like that. And we updated it as much as we can. I think Trace's example, sure. Real-time updates is the gold standard. But that example of a bunch of musicians and writers coming up with a song in the middle of the night at the studio and having it on the radio that day, as much as we'd like to have the information up that next day, the song splits in today's world, there's a good chance they're not going to be settled that next day. And you'd rather wait than have the wrong information up there. So I think ASCAP and BMI and publishers like Sony ATV do our best to get the most accurate information up as fast as possible, but you're working within the constraints of a creative environment.
Thank you, Peter. Let me move on to another topic, which is the 4 core principles approach that ASCAP and BMI have talked about quite a bit yesterday. And I wanted to get the perspective of the licensees and our publisher representative. What are your thoughts about this 4 core principles approach, and what, if anything, is missing from your perspective? And Rick, I know your organization talked about this. Can you give us your views on this.
Sure, thanks. First, just to make sure this is out of the way, I think Mike or Beth talked about this yesterday. If the core four principles or any core is based on a sunset, which is really a termination of the decrees, that's something that is just simply unjustified. There's no, as we've talked about, there's no more competition today than there was in 1941 or 2016, which is really the relevant metric. So anything that's tied to a sunset just is not workable, because 6 months from now or 6 years from now, it's still an anti-competitive enterprise, the PROs. But putting that to one side and looking at these, core four principles, some people call them like a skinny down decree. We've at NAB, first of all, very much appreciate ASCAP and BMI attempting to work towards something they feel like could capture certain important features of the current decrees. And I believe they're making a very good faith attempt to do that. I do want to say, however, that I've not talked to any licensee, including NAB, who has found the core four principles sufficient by any means. They're still falling far short, but it's a good faith attempt, and I think it's something, getting to your question, that it's something worth thinking through. But again, it has to still address the very clear anti-competitive effects. Just to highlight a few things for discussion quickly. We talked about similarly situated. That's dropped from the core four, so that's missing. And as you heard, licensees have talked about, that's a very important piece. It also eliminates the through to the audience requirement, which is critical for radio and TV stations. The reason this was put in is because the PROs before could charge impose tolls sort of at every step of the distribution chain and charge for the same thing. So through to the audience is a critical requirement that's missing as well. We also have some concerns over the proposal to remove the decree's open membership requirement. We believe that will result in the proliferation of yet more PROs, which again, it's not more competition, it's just more opportunities to violate the copyright laws by having to cover off more licenses at super competitive rates. So that's a concern. The skinny decree proposals that we've heard about also that are in the public, also in the core four, it also eliminates the prohibition on licensing rights other than performance rights. And they're just something that we have to think through. And I think the message here is this is all very complicated, and so it really has to be worked through. It's not going to happen in a roundtable, but there is a danger that we have to worry about of anti-competitive leveraging if this restriction is lifted, because it would allow PROs to say to potential licensee, well, they can't have the performance rights if they don't take the mechanical rights too. So that's something that, again, I know that's what was a concern in the past. Again, that's still the same concern is out there. Again, not necessarily prohibitive, but something that needs to be thought through very carefully. And the last one that's not there, we just talked about, so I don't have to go into detail, is transparency. We believe that's essential. If you don't know what you're getting, Senator Smith said this yesterday, if you buy something and don't know what you're getting, it's really impossible to be held liable for it. But under the law, we are. So we think that needs to be part of the discussion as well.
All right, thanks, Rick. Let me see if John, hopefully your audio is getting better. Do you have anything to add to what Rick said?
I'm not sure if I'm not hearing the echo, so hopefully no one else is.
I think it's good now.
Okay, good. Sorry about that. I don't have too much to add to what Rick had to say. I do think that with the proliferation of PROs, we really should be looking at a framework that brings everyone kind of under the same antitrust guardrails, as opposed to going away from them. But something that I'm trying to square, we're in a highly competitive business. My members are in a highly competitive business. They compete every single day for customers with the bar across the street or the restaurant downtown or whatever it may be. And we're talking about transitioning these four pillars or a skinny decree. And I'm curious what the argument is in terms of how that promotes competition that benefits consumers, in particularly. It was mentioned yesterday, I think, by NMPA about it benefiting ASCAP and BMI, and obviously it would. They're the ones who put them together. But again, I would echo what Rick said. I applaud them for that, and I think that is a good faith effort, and I think it's part of the conversation. That's good. But I just wonder what that gets at the end of the day, if that's what we're trying to do here. If the consumer at the end of the day is what the end user, what we're looking at. So I don't know. That's kind of where I am on that issue.
All right, thanks. Thanks, John. Let me ask Peter to weigh in from the publisher perspective. Is anything missing?
Yeah, well,
on our list, and then I'll have Stu respond.
Well, I think most people know what I'm going to say. I mean, Sony ATV is supportive of the four-core approach. We'd like it to be a five-core approach, which is the ability to withdraw digital streaming for the reasons we discussed earlier and that are discussed on seems like every panel. But so we want five cores.
You go ahead.
Is that me? I'm sorry, I couldn't hear you.
Yeah. Do you want to respond to any of these points?
Yeah, I'll try to tick off a few pretty quickly. Through to the audience, I think the proof is in the pudding that BMI provides those kind of licenses well beyond what we're required to do under the decree. Rick mentioned the open membership, and his nightmare is that there will be a large number of other PROs, all of which he thinks is going to have monopoly power. I think if you take that to an extreme, that makes no sense. But in any event, I again come back to the idea that it's not the job of the BMI decree to prevent or introduce or limit other competitors from coming in to the marketplace. And I find it very odd, the idea that if BMI is the monopoly that Rick's been saying we are, that he wants to concentrate yet more affiliates, more members in our business. It just seems to be counterintuitive. Multiple rights, I think, was mentioned. I think it's important to note that our proposal is either going to work or it won't work, but we're certainly not going to make our affiliates grant us rights they don't want to grant us, and we're not going to make customers take rights they don't want from us. We're not leveraging our performance right purported power into other businesses. It is an additional competitive option. It's a way that smaller publishers might be able to compete with some of the larger publishers because they may lack the resources to individually pursue licensing multiple rights, but we can do that on their behalf. We see it only as pro-competitive for the marketplace.
Well, I think we have time for one or two more issues, so I'd like to try to get those in. One addition to sort of this four-core approach that we haven't talked about yet is the proposal to change the interim fee provisions of the decrees. Today the court has to pre-approve interim fee payments, and ASCAP and BMI want to make interim fee payments a condition of getting a license upon request. So I wanted to hear views on whether that makes sense, and should ASCAP and BMI have more authority to set and collect interim fees without involvement of the rate court? And Trace, can I ask you to respond on that?
Sure. The current structure for the immediate licensing followed by the determination of a fee really provides the right incentives for the PROs to get new fees in place. I guess I'm just worried that sort of dropping or amending that requirement just risks, not being able to get a license because we can't agree upon what the interim fee would be. And that sort of is contrary to what the purpose of that license upon request provision is. I've heard arguments that companies go insolvent or go out of business before the interim fees are set, and that I understand that point of view, but I haven't seen any evidence. I'm not sure if maybe the panelists are going to present some evidence about that today. But in terms of iHeart, as an established business, it's not a risk that I think is concerning for businesses like ours. But by the way, I mean, most of our business, the interim fee is essentially a rollover of the prior fee is sort of how things have worked historically. This is really about the protection for smaller businesses, and again, sort of going back to the point I made earlier about innovation, facilitating innovation, without the fear of not being able to get a license.
And Peter, what are your views on this?
I mean, for us, interim fees are really crucial. I mean, to the extent that the requirement to grant a license upon request remains in effect and the rate court system remains in place, we think ASCAP and BMI have to have the ability to demand interim fees. It's just too good to be true. If you walk in the door for a license and you get a license, that it could be years before payments are made with how long it takes in the rate court system. And that's not just theoretical. I've seen it happen where years go by before you're paid by companies that are actually building a business off of the back of music publishers and songwriters. And we just don't think that that's what the consent decrees were designed to protect. So interim fees are extremely important.
Thanks. Stu, did you want to respond to any of the points that Trace was making?
Yeah, I would, a couple. One is the whole idea about our proposal is to stop having fights over what the interim fee should be. Our proposal is automatic. If you're a prior BMI customer, pay what you paid us the last time. If you're a brand new customer, pay what your competitors are paying. It's simple, it's easy, and it's fair because we've lost literally $1 million on some licenses where people have applied, used, and gone out of business. The other thing, Trace, and I love you, but I got to mention that the radio industry litigation is proof of why we need this. When we were negotiating a new license and you applied, the RMLC applied for an interim, for a rate court license, the RMLC instructed its users not to pay us, that we were in the interim phase and simply don't pay BMI, and that shut us out of potentially over $140 million a year. It shouldn't have had to come to that, and I think the RMLC was betting that we were not going to go to court on this because, as you know, rate court's expensive, and our choices are go to rate court or sit there and take it. We did go to rate court, and once we got to the point where this was become a real dispute, the RMLC folded. They paid us what they should have paid us from day one, which is their fees under the prior license. We're trying here to eliminate disputes. We think that music users, any good, solid paying music user should want this because it's unfair for their competitors to suck their customers out and not pay a dime to BMI. It doesn't work for anybody.
All right. Thanks, Stu. Let me I think we can squeeze in maybe one more question here. And I wanted to just, since we've talked a little bit about the rate court, I wanted to get perspectives on, is the rate court working well for you? And can anything be improved about it? And is there a way to impose sort of greater market discipline on prices within the rate court structure? Let me ask Peter first if he has any thoughts on that.
Well, I mean, the rate courts are I think, the least practical way of resolving rate disputes. They're extraordinarily expensive and time-consuming. The only ones that really benefit are the lawyers, and we're all here lawyers. I understand and support why ASCAP and BMI and why that's part of the Core 4 approach. It is important to licensees. But right now, that the reasonableness standard that somebody mentioned a few questions ago, I don't think that really accurately reflects a rate that would be arrived in a free market negotiation. We've got a new provision. We've got the MMA has given me some hope because now evidence of benchmark deals in the marketplace or prior deals in the marketplace will now be able to introduce into evidence into rate court proceedings. And hopefully that's a step in the right direction as long as we're going to live with this system. So something approximating a fair market rate can be achieved.
All right, thanks. Rick, do you have any thoughts on the rate court?
Yeah. I mean, the reasonable standard is something that's used all the time by courts in antitrust litigation. So I don't understand. I actually don't really comprehend why that's not something. If you're looking to arrive at a fair rate, why that's not the standard. That standard has worked well. It's important, and it's important that the standard be applied in a competitive market, not an unconstrained market. Right? That's unconstrained market would allow those with the monopoly power to exercise it. So in a competitive market, that's worked well. It has been essential because again, it's really in the interest. It's not about Stu or anyone else at BMI or ASCAP. It's in their interest to try and drive the rates up as high as possible. So they're going to ask for the highest possible rate. And for the court to look at what is reasonable. Again, this is not some foreign concept that no one has any experience with. It's well worn, and that's essential, and that is working well. And again, of the things we shouldn't change, that certainly is one of them.
And let me give Stu the last word on this issue. Any thoughts on this?
Yeah, thank you. We think rate court works reasonably well. We don't think it works as well as free market negotiations, but on the road to deregulation, we're not looking for, other than the interim fee modification, any changes. I think you measure the success of rate court as much by the cases that never get there as the ones that go to trial. It is a reality when both parties are staring at the bills that we get from our outside lawyers, waving to them right now. It is a real factor that you take into consideration. And so I think, it works as well as it does. I don't have a particular problem with the standard that's applied. I don't want you to hear that I'm equating that with free market negotiations, because we're definitely not. But as a model, for as long as we'll keep it and preserve the protections as we work towards deregulation, as modified by the MMA, as I believe Peter said, we're fine with it.
All right, thank you. I guess I had one follow-up that was suggested based on some of the discussion yesterday. And I was wondering, Stu, could you tell us anything about whether BMI is planning to make public a proposed revision to the consent decree? And also, can you tell us a little bit about when you'll be releasing some details about the Songview project that was discussed yesterday? I don't know if you could give us any more detail on those things.
Yeah, regarding the modified or the draft modified decree, I think there's going to be a time when we're certainly going to have to disclose that for everybody to consider. To be candid, we've tried first to see if this is a model that might fly with some of our key users. I think everybody thinks an ideal solution would be to come to the DOJ and say, here's something that we all can live with. And before we get everybody's opinion, we thought we'd get a few opinions first. So I think there'll be a time when we're going to disclose that to a larger circle, but not just yet. On Songview, I think you heard mention yesterday that we're working towards a launch by the end of this year. I'm going to leave it to my Corp Comm department and folks who know the project better to get into all the nice new features and functionalities. But it's a real thing. It's been a long process, and we are hopefully months away from being able to share it with you.
Okay, great. Thank you. It looks like we are nearing the end of our allotted time. So I do want to take a moment to thank everyone. I think this has been a very interesting discussion, and I really appreciate all the thoughtful contributions that our panelists made today. So again, thank you for being here. So I think that will wrap up our panel. So thank you again.
Thank you.
Thank you.
Great. Many thanks to you, Ben, and to your panelists for that fantastic debate on some important provisions in the decree.